Welcome, everyone. Today's live thought leader webinar is entitled Post-2022 Real-World Impacts of Stark Law and Regulation Changes. This webinar is brought to you by Intrax. This live webinar will last 60 minutes, and at the conclusion, there will be an opportunity for Q&A. To submit your questions, simply use the Q&A feature at the bottom of your screen. Now, I will turn the presentation over to our first presenter.
Good afternoon, everyone, and thank you for joining us. My name is Stephanie Haywood with Intrax, and I'd like to take a couple of minutes to introduce you to our speakers today. Sarah Lowe is a certified healthcare compliance professional who brings 19 years of leadership, operational experience, and technology solutions development in the healthcare compliance space. Throughout her career, Sarah has served as an in-house compliance expert for health systems and has largely served as a compliance expert for SaaS, software as a service companies. Currently, Sarah is the Vice President of Strategy and Operations at Intrax, the leading contract management solution for healthcare organizations across the country. Intrax is uniquely driven by the expertise of dedicated contract compliance professionals like Sarah, and is proud to be strategic partners with Hall Render. Ritu Cooper, who also joins us, is a shareholder at Hall Render, Killian, Heath, and Lyman. Hall Render is the largest healthcare law firm in the country. Ritu's specific area of practice is fraud and abuse and compliance. She represents providers such as hospitals, health systems, large medical practice groups, as well as pharma and device companies in the space of fraud and abuse. Ritu also co-chairs the compliance service line at Hall Render. Day to day, Ritu provides counseling to clients on how to be compliant with fraud and abuse. Ritu also helps providers establish compliance programs, conduct internal investigations, respond to government investigations, and sometimes resulting in voluntary disclosures. Last but not least, Ritu helps a number of clients manage the requirements under their corporate integrity agreements. I will now turn the presentation over to our speakers. Sarah?
Thank you, Stephanie. Thank you to AHLA, and a very big thank you to Ritu for again joining me to discuss these very relevant topics, and also a thank you to everybody that's joining us for today's topic. Before we get started, I wanted to briefly introduce why we're doing this together for those that may not be aware. Intrax and Hall Render have been very close partners for a number of years, and actually Intrax was initially founded by Hall Render back in the 80s when floppy disks were still a thing. Intrax actually used to reside on a floppy disk. Thankfully, technology has evolved so that the partnership between Intrax and Hall Render has continued, and it remains unique in the industry given that we're both focused on healthcare. And that's why we continue to join together to present on topics like these. So last year, some of you may have joined us, and it was actually about 15 months ago, we discussed the newly released CMS updates to Stark and Anti-Kickback that some of you may be relatively familiar with. And we also had some suggestions for how healthcare organizations may apply them to their day-to-day. We primarily focused on the clarity and definition that was offered around fair market value, commercial reasonableness, and the impact on value-based arrangements, in addition to some of the relaxations and clarity around documentation requirements. Before we dive into the discussion, though, we wanted to start with a few polling questions to help us address the topics most important to today's audience, and we have 3 that we'll go through consecutively. And the first one is going to tell us a little bit more about who's actually in today's audience. And I'll read them, and you'll have an opportunity to answer before we move to the next. The first one, what is your role within your organization? And it's a single choice. Are you in-house counsel? Are you in-house compliance officer? Are you with a private law firm, a consultant, other, or are you a vendor? And we'll pause to allow everybody to respond. Okay, it looks like, as predicted, we have The majority of folks joining today are in-house counsel, so that, again, is not a surprise, but glad to see the varying responses there. We'll move on to the next question. Polling question number 2, and you have multiple response options here. Has your organization changed its physician contracting methodology based off of last year's updates? And you can, again, select more than one. The answer options are yes, we've entered into value-based arrangements, or yes, we've changed our documentation requirements for commercial reasonableness, or yes, we're in the process of changing our documentation requirements for commercial reasonableness, or no, we haven't changed our documentation requirements or entered into value-based arrangements. And I'll pause here again to allow folks to answer. Feel free to, if you have answered yes to any of these, to use the comments to tell us a little bit about how you've rolled some of this out. Okay, looks like we've got a lot of responses in, and the majority are, interestingly, no, and that you haven't yet changed your documentation requirements. And coming in second behind that is that you started to enter into value-based arrangements, which is great because we're going to spend some time talking about both the documentation requirements and some of the topics around value-based arrangements. And then we're going to move into our last polling question. Okay, I'm most interested to learn about today, and again, you can select more than one here, tools that may help your organization mitigate risk, streamlining your processes within your organization, cleaning up your organization's data, or transitioning your organization to a more value-based enterprise. Give everybody a little bit to answer. Okay, it looks like overwhelmingly everybody's interested in tools to help your organization mitigate risk. Again, great, because we're going to spend a lot of time, 82%, wow, that's a lot. We're going to spend a big chunk of the time talking about ways that you may implement in your organization to mitigate some risks. So thank you everybody for participating in those polls. It's really helpful. Moving into our discussion for today though, and again, when we discussed this last year, we had several questions from the audience on how the new updates would apply to value-based arrangements, and also there were some questions about how that applied to employed versus contracted physicians. And I think we will, as we move through the topics today, we'll probably answer and touch on those where we feel like they're answered, but please feel free to introduce some new questions into the panel as we move on, and we'll answer those at the end of today's conversation. But before we discuss the year in review, as these new updates have been applied in practicality over the past 15 months, Ritu, would you please do a brief refresher of last year's takeaways?
Sure, thanks, Sarah. So as we all know, there were a number of changes to Stark and Kickback in the new rules that came out, I guess the end of 2020 and then effective 2021. Most of us focused really on the value base, but I think there are so many things that we need to learn or pay attention to, like commercial reasonableness, the definition, some of the commentary around fair market value, the writing requirements. So there's a number of things. And so Sarah and I thought that this quick little chart was a good way to kind of give you an overview of all of the changes that were in the Stark and Kickback updates. But in terms of what we talked about on our last session and kind of some of our takeaways. So one was obviously these new rules are providing for some new opportunities for compensation in the ways that we can compensate individuals and move more towards that value-based work where we really want to move. But I think that with those flexibilities and the ability to be able to have some more value-based payments, we're going to expect some more government scrutiny. And we'll talk about later some of the things that we've seen in terms of government scrutiny, but we thought that we would see some more government scrutiny, especially because we now have a clear definition of commercial reasonableness, and then, of course, some information related to fair market value. For example, we used to believe that with fair market value, that the government only expected surveys, and that was it. They looked at surveys and that's all that they relied upon. And that was really from case law and dealing with their experts. But in this new commentary, they've talked about how survey data alone is not the only factor that's considered in fair market value. And so I think that's been a huge benefit for our clients in terms of looking at the extenuating circumstance. And so again, with those relaxations or that commentary from the government, I think there is an expectation for us to be able to track that. The second thing that we talked about was collaboration. And I think that goes hand in hand with fair market value and commercial reasonableness. And it's that collaboration between the outside consultants that can provide that third party opinion on fair market value and commercial reasonableness in our providers, and really working with those evaluators in trying to figure out what is needed to be able to support the arrangement from a commercial reasonableness and a value, and a fair market value perspective. The third thing that we talked about was documentation, and how it is going to be really important to document throughout the life cycle of the arrangement, not only fair market value and commercial reasonableness, but as we know with the value-based arrangements, we don't have to show fair market value and commercial reasonableness, but depending on which exception you're relying upon, there is an expectation of auditing and monitoring. And so in order to do that, you need to have that front end documentation established. And I guess the last thing that we really covered was, how do we then utilize a contract life cycle management solution more effectively to help us with our compliance with Stark and Kickback? When we talked last year, we did talk that there were a number of clients that we've dealt with that still have maybe paper tracking, or if they do have a contract management solution, they aren't really using it to its fullest potential. It's really just a repository. And now instead of it being a paper repository, it's an electronic repository. So I think those are probably the four big takeaways, or the big things that we talked about last year. But Sarah, before we get into like the legal side of what we're seeing, now that we've had 15 months or so, like you said, for organizations to react, what have you seen in terms of the changes in the contract processing, and how has that evolved?
Yeah, absolutely, Ritu. We've seen a lot of clients be much more intentional about their contract processes at the very basic level. They're much more intentional about streamlining and centralizing best practices in their workflows, particularly in this continuous era of mergers and acquisitions. In that environment, it's really easy for inconsistency to happen among organizations within a larger organization. So we're seeing, at least our clients, they're being very, again, like I said, intentional to make sure that all of the appropriate checks and balances are in place prior to even thinking about beginning to implement that contract approval workflow solution like you were mentioning before. It's not just a repository. So this is a really important consideration prior to their attempting to wrap a workflow solution around what may be a potentially broken process. And we have also seen that happen before too, and it can result in maybe in an unsuccessful experience with a contract management system. So that's really important. We've seen a lot of intentionality in requiring a good process be followed. So that would mean a consistent contract initiation process. So really that place where someone is making a request for a contract and demonstrating the purpose of it or the need. A consistent contract diligence process, which is where all of those checks and balances are occurring digitally. Also, with drafting the actual contract itself, there needs to be consistency there and intentionality, and the review and approval and signature process. So with with a good process that has been mindfully rolled out and put together, all of those necessary checks and balances can occur on the very front end of the contract. Not only that, as relating back to the contract processes and the evolution of those, we're also seeing clients seeking our assistance or assisting of others even in getting a new set of eyes to review their end-to-end contract processes. And that's really to make sure that they're still current with compliance standards and still current with best practices, because we're here today to talk about how those standards are evolving. So they, in turn, after they've had the opportunity to review their processes, will evolve their own policies and to the workflow solution that's wrapped around them. So it's really important that contract processes be living and breathing, and so should their CLM solution. And then lastly, but not least, too, we're seeing a hyper focus on education and the engagement of the end users surrounding contracts. And that is all the way from the board to each individual business owner. It's education of not just the functionality of the CLM that they choose to use, but also education tied to that of their own processes and policies, the whys behind their CLM solution. So at Intrax, we of course consult with our clients prior to and during and following, and that's really important, the implementation of the CLM to help our clients streamline the rollout of their contract policies and processes at the front end. However, we're also seeing that education, like I said, at the hyper focus, become a more recurring need, and more of our clients are partnering with us to roll out an annual education program that ties together the functionality too, or refresher of the functionality, but also the whys behind why they're using a CLM. And of course, education as new employees are onboarded. So with all that being said, given that clients are focusing in on their processes from a compliance and CLM side, Ritu, what are you seeing on the considerations regarding legal processes?
Sarah, I think very similar to what you're saying. We're really seeing our clients take a very systematic approach of leveraging these Stark and kickback changes that came out last year. So with that, I think with that systematic approach, I think the first is to make sure that they have key stakeholders engaged. So kind of what you're saying about the education, I think they've tried hard to make sure that they have internal stakeholders, so C-suite folks, those that are involved with the contracting process, those that are just out there involved with getting the contracts to begin with, not just the contracting process, but maybe the ones that are speaking with the physicians or the vendors, whoever they're talking to, and getting them all together with outside counsel, with the appraisers, with just discussions about let's work together to take advantage of these regulatory changes. But obviously with that, I think it's the same thing that you're talking about in terms of education. One of the things that we've always had discussions with our clients is, again, going back to the CLM, is the information in that CLM needs to be consistent. The only way for it to be consistent is for everyone to be on the same page. Very similarly with the Stark and kickback rules, it's the same thing. So not only have we been providing a lot of education to compliance and legal departments, which I think is a given, right? Obviously, they need to understand the Stark and kickback changes for them to be able to apply those to any analyses that they have. But it's also being very deliberate of how to then take that very legal type education and operationalizing it and providing operational education related to Stark and kickback, and especially the changes. So we've done presentations with finance departments, with the contracting personnel, with various committees like compensation committees or compliance committees, really to help them understand what do these changes mean, and with those changes, what do they need to do operationally? Because then the next thing that we've seen is organizations taking those changes and trying to figure out, okay, well, now what updates do we need to make to policies and procedures? What updates do we need to make to our contract terms? A lot of questions that people would ask during these education sessions was, well, we see now that we don't have to have a writing for 90 days or we don't have to have a signature for 90 days. And we have to say, no, no, no. It's not that we don't have to have that, because the best practice is to have that at the outset. It's just that if we don't have it right away, we have this 90-day leeway. And so a number of our clients have chosen not to update their policies related to their requirement that they have a writing and signature at the start or prior to the start of an arrangement. What they have done is they've tweaked things like, because they also don't want to violate their own policy, is stated that should you find yourself not in compliance, like having an arrangement that hasn't been signed or isn't memorialized in writing before the start of it, refer to compliance or refer to legal to have a discussion. And then obviously at that point, compliance and legal can look at it and say, okay, well, we have 90 days. We're not at a point where we're out of compliance so that we need to make a self-disclosure. A lot of our clients were very worried that if they made the change in their contract, in their policies related to contracts, and said, oh yeah, no, don't need to memorialize it for 90 days, or don't need to have a signature for 90 days, then we'd be looking at post 90 days, which then would fall out of compliance. So I think there's been a lot of that discussion. I know a number of our clients debated on how much information to give to the operational folks related to the changes, because they were worried about, they've worked so hard to curb behavior now, to make sure that contracts are in writing, to make sure that we've memorialized fair market value and commercial reasonableness, to make sure that we have a signature, to make sure that the purpose of the arrangement is within the document. But they then did not want their operational folks to talk to people around town who may have heard about these changes and believe that compliance and legal were not up to date with the latest and greatest of these changes. So a number of our clients chose to say, okay, we will explain that there are some of these flexibilities, but we as an organization are choosing to be a little more rigid because we don't want to fall so close to being out of compliance. So I think those types of discussions have been occurring and allowing both legal and compliance to have a seat at the table so they can strategize with the operational folks.
That is really interesting, Ritu, in talking about how you're seeing your clients really not necessarily adjust their policies to be more lax, but to keep them a little bit more restrictive to be on the safe side. And on that note, I'm going to switch gears just a hair. It hasn't been too long, like we said a couple of times. It's been about 15 months or so now since the updates have been released. But have you started to see any trends in early cases begin to emerge yet?
So the short answer is not really, Sarah. There were about, I think, 55 or so cases and settlements that have come out in the last year that I reviewed that had some sort of allegation of Stark and kickback violations. And I didn't really see a difference in the allegations per se, right? We're still talking about, they believe that the arrangements are for the purpose of capturing referrals or things like that. But one thing that was kind of refreshing to see is that for so long, the government always would argue that there's a loss of profits. And therefore, because there's a loss of profits, the arrangement cannot be commercially reasonable. And now that we have this definition that provides clarity on what commercial reasonableness, and then the government very specifically commented that the lack of profitability does not mean that an arrangement is not commercially reasonable. In the last 18 months, I haven't seen any of those allegations or any of those comments made about profitability, which has definitely been reassuring. So that departure, I think, is maybe one change. But otherwise, there still were very large settlements for kickback and Stark violations. And there was one case that I thought was pretty interesting. And that was this case, Flower Mound Hospital, where there was a settlement last December. They settled for $18 million. And what the government alleged is that Flower Mound is a partially physician-owned hospital. And what they did was they reclaimed their shares from their older physicians who were over 60, and then they reallocated them to younger physicians. And what the government alleged was that they were taking into account the volume and value of referrals, that the the 60 plus physicians were not going to be sending so many referrals. And so therefore they didn't want them to have that ownership interest. And then they based the reallocation of shares to the younger physicians based on their referrals and how high their referrals were. And so I think that, again, not that that's a departure, but I think because we got that definition of what it means to take into account the volume and value of referrals, and that there has to be a correlation related to the compensation and the referrals, and they have to be in the same direction. I think that this one case was one of the ones where I think that they probably talked about that methodology a little bit more specifically, but I think it might still be a little bit too early to see where these enforcement trends are. The cases that settled or were determined in this past 18 months were likely those that were filed earlier or pre-2021. So I think it'd probably be a year or two before we really see the trends. But I think one thing that we probably can look to is, if you guys recall, one of the reasons for some of the technical changes to STARK, as CMS described, is that they had this ridiculous backlog of submissions to their self-referral disclosure protocol. And a lot of those were because, remember, STARK is strict liability. Either you meet an exception or you don't. So either you had something in writing or you didn't. Either you had a signature or you didn't. So there were so many submissions that were really just technical in nature. And so I think if we look at the backlog, and if that backlog has been reduced, it likely is going to show a difference. And in talking to some of the CMS regulators, they obviously can't refuse to accept a submission. But what they have stated is that on a number of occasions, they've invited providers to reevaluate their submission to see, do you really think that you have a violation in light of what the STARK law looks like right now? So I think we likely are going to see a reduction in that backlog. And when we do see some of those submissions to the self-referral disclosure protocol, and we then see them on their website, whether it's an advisory opinion or a settlement or what have you, I think we'll see some changes in terms of what's going through the protocol, because it likely will not be the technical violations.
Right. I think that's going to be really interesting to watch the trends. As you mentioned, it may be another year or so before we really start to see the things shake out there. And of course, if we do a part 3 to this webinar, we can absolutely review those, and I think we should, as part of that conversation.
Was that a hint to Tanika, Sarah?
yeah, I think it was a little bit of a hint drop. So moving on, sort of piggybacking on what you were talking about a little bit, as you were talking about commercial reasonableness and documentation, which was one of the other major things that we talked about last year. Now that we have a clearer definition of commercial reasonableness and what may be required there, are you starting to see an improvement in the factors that are considered and may be required to be documented?
Yeah, I think so. We've been working with clients for a long time in having like either a compensation committee or having some sort of policy of what are the trigger points to then take an arrangement and have it go up for further review, whether it's at a compensation committee, whether it's at the board level, but having a little more discussion related to it. And so usually that's if the compensation is, not within that 50 to 75th percentile, to have a little more discussion. When we did it back then, as I was stating earlier, our belief always was, and this was all based on case law and the government's discussions, that they really just rely on, well, one was a profitability issue for commercial reasonableness, and then for fair market value was just the survey data, right? So many times we always felt that we were so tied down to whatever information went into these surveys. And as we know, the survey data that's out there is only as good as the physicians that submit information to the survey data, to the surveys. So you're kind of looking at that data, and when you say you're an outlier, you have an outlier, it doesn't necessarily mean that it's not fair market value or reasonable, at least in our opinion. So it definitely is refreshing that the government has now finally acknowledged that fair market value is not just survey data, that it can be more than that. And so I think that has really pushed our clients to be very deliberate in their discussions, especially at like a compensation committee or at the board level, about what are the extenuating circumstances related to the compensation. Why are we paying more? Why does this particular individual require more compensation? And for it not to be for what the government would call a nefarious reason, right? For it not to be that it's for capturing more referrals. That's not really what it's for. And most of our clients, that's not what they're looking at. They're looking at the need that they have to fulfill, right? Or the fact that they have this rock star physician that they want to continue to keep and not lose to another provider, because this individual is taking care of their patients and is meeting a need for them. And so, and if you've got someone who is working over the 90th percentile, well, then the compensation should be aligned with over the 90th percentile of fair market value. So I think that there is that deliberation that was occurring, but now it's much more detailed. And then of course the documentation, I think, goes along with it. So when you're looking at commercial reasonableness, are we citing what the commercial need is? Are we citing, for example, I mean, I had clients years ago that would have difficulty recruiting a particular specialty to their area. And the discussion was constantly, well, we keep getting beat out because this other organization feels that they can pay more. But in our town, we feel that based on the survey data that's available in our region, this is all we can pay. And so having that very deliberate discussion about what's the need, what are all the efforts that you've taken to try to recruit, what are the shortcomings in that recruitment? What has prevented you from recruiting? Why is it taking so long? And then making the conscious decision of saying, well, perhaps there are other factors that we need to consider. And so I think with all of that, these compensation committees are going to become very, very valuable in helping to set that tone. So with that, right, Sarah, so I can talk all day about what they're doing in terms of their discussions, but with that, what kind of baseline performance metrics, or what types of things do you think need to be established on the CLM side so that organizations can most effectively use that CLM to then bolster their documentation and their support, I guess?
Really, it's, there's emphasis on it when you were talking about the documentation and facilitating the discussions that need to occur if there's extenuating circumstances about paying somebody over the 90th. It's really important, and going back to the process improvement discussion that we just talked about, particularly in the diligence phases of a contract, which is really where all of those checks and balances we keep talking about should occur. The process that they're wrapping a solution around should facilitate those conversations, and the checks should be documented that they're happening. It doesn't mean that all of the discussions need to happen in the CLM, but the facilitation of the compensation committee to review extenuating circumstances or document those should be documented as part of their process requirements. And again, it's really helpful if that happens early on before there's actually a contract that exists. So again, when a new arrangement is initiated, that clear documentation of the commercial reasonableness, it shouldn't be optional, it needs to be required. And that includes documentation of the factors that were considered when establishing the commercial reasonableness so that they can be referred back to again. And that's for every individual contract. It's not a blanket statement across multiple contracts, it's for every individual arrangement, like we've touched on a little bit. So some of those things considered when determining commercial reasonableness could look like establishing a community need or accreditation needs or business needs or other business factors that may have been considered in establishing that contract as reasonable and commercially reasonable, but their CLM should require the documentation of those considerations. There also should be specific expectations for performance of that individual contract documented. So how is this physician expected to perform, and what does success look like? What measures need to be or should be included to establish that that provider is successful in performing according to that contract? What are those metrics that are going to be used to evaluate the performance on a recurring basis? That needs to be documented, but it also needs to be reviewed and approved, and that again goes back to a good contract process. All of those things need to happen at the onset of the agreement, like we've talked about multiple times, but also after the contract becomes an actual live contract, after it's executed, which is going to be a recurring theme. I think you're going to hear both Ritu and I say that it doesn't stop at signature. It needs to be continuously monitored. So transitioning again, that seems to be my role. I keep transitioning as a way to new topics, but another one of the major things that we discussed this year, and it seems like a good majority of people or percentage of people have interest based off of our poll responses, I'm going to transition us on to value-based arrangements. So with that, before we dive into the detail, Ritu, are you starting to see any momentum in the clients you're working with from performance-based to a more value-based arrangements? And if you are, do you have any prediction on how those trends may continue?
Sure. So yeah, Sarah, I mean, I think that we've had a number of clients who, I'm sure they're attending all of these education sessions on value-based arrangements, that are trying to really understand what they can do and what they have a tolerance for. To date, I haven't really seen any clients take advantage of the full financial risk exceptions under Stark and Kickback. I open it up to the audience. If there is someone out there who has, please put something in the chat. I'd love to know about it, but I haven't seen that, and we haven't seen that. I've talked to a number of my colleagues who also work in this space. The majority of the arrangements that we're seeing really fall in that the value-based arrangement exceptions, so the no risk. Some are in that meaningful downside risk exception under kickback, or the substantial downside risk. But many of them are starting small, right? So they're kind of tiptoeing into this area. They're taking some steps that I think is to help them, right? So one of the things under the value-based arrangements is you have to have a value-based enterprise, but nothing in the regs requires that the value-based enterprise needs to be a separate legal entity. So for the vast majority of the clients that we're dealing with, I have not seen a creation of a separate entity to be the value-based enterprise. Instead, the way these clients are establishing the value-based enterprise is doing that through contractual arrangements, where the contractual arrangements would very specifically detail all of the participants that make up the VBE, and what they're doing to collaborate in order to move forward their value-based purpose, and what activities that will entail. So it seems much more contractual in nature. And so I think that's a good step in moving in this space. We may, in a few years, see that organizations want to establish these entities, but right now, because it's not a requirement, I'm not seeing that much of this establishing a whole separate legal entity, kind of working with what we can. That probably is also for speed, right? Because I mean, it takes time to put together an entity. So again, I think having that contractual arrangement and establishing the VBE is really a trend of right now. In terms of the governing documents, I'm really seeing clients putting together really straightforward documents that really are just kind of checking the box and the list of all the things that they need to establish in order to have that value-based enterprise and that value-based arrangement. A lot of our clients are transitioning existing arrangements into VBE. So employment arrangements are having a value-based component to it. Medical directorships, co-management arrangements. If you recall, I think last year we talked about this, but one of the challenges with co-management arrangements when you're trying to meet the regular Stark and Kickback exceptions for personal services is you still have to have fair market value and commercial reasonableness. A lot of the evaluators that we've dealt with in the past, when they're evaluating the co-management arrangement, they fall back on the number of hours that are being expended and the amount of time per hour. So it still circles back to, even though you're doing this co-management arrangement that's supposed to be related to what I would call a value-based activity, right, for outcomes and quality, we're relying on the personal services arrangement exception. I now think that which is why we're seeing a number of our clients reevaluating their co-management arrangements and saying, okay, well, now we don't need to have it fit in a personal services arrangement. Let's have it fit into one of these VBE exceptions and see where we can fall. So then, ensuring that there's a value-based enterprise, making sure that they have an accountable body, making sure that if there is some in-kind remuneration that's being provided, that there's a proper coverage and payment for that, but the 10%. So there's a number of things that are being done there so that they can not have to rely on that fair market valuation, because a number of clients would constantly kind of be upset that at the end of the day, we're still basing all of their work that is committee work and attending things that don't necessarily have a one-for-one relationship to the outcomes that they're achieving by paying attention. So I think that is probably the biggest move that we have seen, is reevaluating those co-management arrangements. We've had some clients that have put together arrangements that are based on quality. So for example, we had one client that was dealing with a situation where, as a hospital, they felt that they were getting some repeat patients that were at like area nursing homes, where the quality at the area nursing homes was not up to a standard that they felt was appropriate. And so then they entered into an arrangement with them so that they could help by providing staff, helping to monitor some metrics for quality, so that they could then see a reduction in some of the readmissions. And so I think that there's a lot out there. I think people are trying to be very creative, and I think they will continue to be. The one area that I think some of our clients are still struggling with, which is that idea of how do we monitor, how do we ensure that we're staying compliant, right? Because the regs require that at least annually you take a peek and you ensure that you're still providing services primarily providing services to the target patient population they've identified. Obviously, there might be some outliers, but it still needs to be primarily for that population, that you are engaging in the value-based activities that you said you were going to engage in. You still have that same purpose. And so I think that monitoring piece is the part that organizations, again, we're only really 18 months into when the regs became effective, 15 months since we all talked last year. I think that's the part where organizations are really going to have to try to figure out, is what does that monitoring look like? I know the regs say at least annually, but should it really only be annually? Should it be quarterly? Should it be at some interval that's a little bit more? So that's what we're seeing sort of in terms of trends. But with that, Sarah, since I mentioned that our organizations are kind of not struggling, but they're trying to figure out how to accomplish that monitoring. Do you have any suggestions on how they can do that oversight in a practical way?
Yeah, absolutely. And this is really where having a well implemented and a really well adopted, that can't be understated, or overstated, excuse me, a really well adopted CLM solution is going to come into play. So I'm going to review some of the practical ways that the monitoring of a value-based arrangement can be implemented, but also some of this is going to be applicable to all types of contracts, but I'm going to focus right now on value-based. So like we mentioned earlier, the management of a contract begins at its need or its idea, all the way through its life cycle, not just at the onset. And I'm going to keep beating that drum every chance that you give me to say it, Ritu. From the documentation of the intent of that contract, the purpose of it, and especially in the value-based arrangements, the purpose of it, the performance expectations and measurement of them, all of those decision points need to be really well documented. And once they're documented at that onset, at least in the NTRAC solution, they become reportable. And then once they're reportable, they become usable data points that are going to assist with compliance and then the ongoing management. But again, getting back to the establishment of the initial arrangement, the finalized contract's got to be managed too, and that's probably where you're hearing your clients running into the most concern. So the CLM should include, at the very basic minimum, notifications to identified cleanly and clearly, and I say that on purpose because a lot of times this gets blurred, but identified contract responsible parties. So the business owners that have the most knowledge of that particular contract. The contracts at this very basic level should get notifications of its upcoming expiration and any renewals that may be in place. But regarding value-based arrangements specifically, there needs to be the ability of a CLM to establish additional notifications of other critical milestones. Like you mentioned, with value-based arrangements, there's the original purpose of it that is established at the beginning, and maybe the intent of serving a targeted patient population. That needs to be continuously evaluated to make sure that it still has its original purpose and that the population is still being served it was originally intended to be served. So notifications to responsible parties to take notice and evaluate how that contract is performing need to be set up. They can be set up, like you mentioned, they should be able to be set up on any kind of interval, but as you mentioned, probably at a minimum of a quarterly basis to stay ahead of it, but also at any kind of interval that maybe is more applicable or more appropriate. Beyond that, evaluating the performance of that contract too. So you're taking a look at the purpose of it and making sure that the intent is still valid to its original intent, but also that it's performing according to the intended outcome. So that also needs to be evaluated routinely, and the CLM should support clients in being able to accomplish those evaluations. And then the responsible business owners can make decisions about that particular contract and take an action on it. Like they may need to amend it. They may need to change some of the terms of the agreement to make it more applicable and more accurate. They may want to just simply renew it, or they may need to terminate it altogether if it's not serving the original intent at all. So a CLM is not just beneficial, I'll go so far as saying it is necessary for efficient and appropriate oversight of value-based arrangements, and like I said before, really all arrangements. Anything to add there, Ritu?
Sorry, I put you on mute. Someone's doing some construction outside.
That's okay.
You know, I think you've hit it, Sarah. I mean, the only thing that I worry about as counsel is the idea of that fair market value, because usually that's protected. So I would say I wouldn't want the fair market valuation actually to be stored in your CLM, because more often than not, that is something that's been obtained via privilege, like via attorney-client privilege in that report. But I do think maybe just in the CLM noting that you have a fair market valuation, or noting that you have an opinion about commercial reasonableness and the date, and then the expiration of that. So outside of the value-based world, right, because we now have indefinite holdover for arrangements, one of the things that the government has stated is that you can have that as long as you're meeting all of the other elements. One of those elements is fair market value and commercial reasonableness, and certainly that could change over time. And so a lot of these reports, the valuations state that they're only valid for whatever, a year or 3 years or 2 years, whatever the time period is. And so I think tracking that in your CLM is probably a good idea, but I would not recommend storing that report. But I know earlier you were talking about the commercial reasonableness. I do like the idea that the commercial reasonableness checklist, as you were kind of talking about the business need or the accreditation requirement that you're meeting or something like that. I do like that being stored. And I think those are factual pieces that may have been used to obtain the commercial reasonableness assessment. Right. And you can have that there without having the assessment itself. Mm-hmm. But I like that what you talked about, that if you, like you said, they're reportable. I assume what you mean by that is that as the entity, I can run a report for all of my specific type of arrangements and what are my due dates, or, you know, when is something expiring or something like that. And so I like that. I like that idea.
Right. And thank you for that. And Ritu, I'm going to jump us ahead to the next question. I've been, my moderator over here is helping me keep track of the time. But I'm going to piggyback just sort of off of what you said, and specifically around your recommendation on FMV and some metrics or data points that may or may not need to be stored. So taking what you said a step further, like some clients may not necessarily want to store their actual valuation methodology in their CLM, but it's important, I'm just going to emphasize exactly what you said, that the documentation that the FMV has actually been done according to policy and the methodology for commercial reasonableness, all of that absolutely should. And when we were talking about reporting, yes, so absolutely, if the data is entered, then it can be reported on. If it's not documented in the system that they're using, then it doesn't really become usable data anymore. It's not even data at all at that point. So having a CLM that facilitates the ability to not only enter the data or make recommendations of what data should be used, but allowing the output and use of it is going to be really key. Also, I wanted to mention too, because we've talked about it a lot, is that diligence part or the initiation part of entering into a new arrangement. That's where an organization has the most opportunity to make sure they're doing things in a compliant way, not just according to their the regs, but also according to their own policies. They want to make sure they're doing things compliant internally as well. But also, let's not forget or overlook that they need to make sure that they're evaluating and documenting that it's a good business practice too. That's something that's really important that needs to be considered in the beginning. And if things are done in hallway conversations or simply over email or even spreadsheet, some of those opportunities are going to be missed. So, Ritu, I think that that takes us to a good segue for a question again for you. And talking again about CLM and Intrax specifically, we continue to make sure that we're evolving our technology and services as the regs are evolving and as our clients' needs evolve, and of course, as we're continuing to work with you and Hall Render. But it's really important from our perspective, given that we've been in this industry for quite some time, that a contract lifecycle management solution has to stay ahead of the curve. And if it's ahead of the curve, then it can become a true partner and relied upon resource, and specifically for healthcare. Given that, Ritu, what are you suggesting to your clients that they consider as they're selecting a CLM partner?
So you mean outside of saying, hey, check out Intrax? No, I'm just saying, no.
Yeah,
but no, with all,
no,
with all seriousness, I think that there are really 4 things that organizations should consider as they're evaluating their current CLM, or if they don't have one and they're getting into one. One is expertise, right? And I think you just mentioned it, that you guys try to stay ahead of the curve. You try to learn about the regulations and the things that are going on out there. So I think you want someone who can help you operationalize that, right? So someone who can sit down with you and you can say, okay, I have these regs that I need to be compliant with, and I need to make sure that I have all contracts signed timely or reviewed timely, or I need to make sure that my payments are in line with what's stated in the agreement. And so that means that your CLM needs to be able to talk to these other I guess software or things that you're using within your organization. So I think that expertise, right? To be able to sit down and have your CLM partner be able to understand what your problem is, because only if they understand your problem can they help you with a solution. So I think expertise is important. The other, which is probably a given, is client service. I cannot tell you the number of clients I work with that state to me that they're working with a vendor and the vendor is not responsive. And that can definitely cause frustration, especially if you're trying to use your CLM as something that's going to help you on the compliance side to be able to run reports, evaluate, determine what are the things that you need to put on your quote unquote to-do list to fix or to review or to audit or to monitor. And if you have any issues, you need to be able to have that, I think, real-time responsiveness from your vendor. So I think it's that client service piece that's important. I think the other is just serving as a true partner. Not being well, I'm outside, I'm a third party, I'm not your partner provider, right? I'm just a vendor. But I think when you're really thinking that you're a partner and you found a vendor that's a partner in this process, then they will be able to help you make a solution that will meet your needs for that. So, and I think with all those three, none of that would matter if they do not have the ability to get technology or produce technology for you that can satisfy what you're looking for. So to me, I think those are probably the four most important considerations for our clients when they're looking at a CLM. And I think really understanding this value-based portion, because obviously this is going to be new for everyone since it's only been out for 18 months, but really being able to look at the value-based and what solution can these vendors provide for the value-based piece, because we need to ensure that we're constantly in compliance with all of those requirements.
That's a really good point, Ritu. Thank you. We are at 12:56, so I think Stephanie has got some questions that have come in. Ritu, really thank you for talking with me today as we do round 2 of our conversation regarding these Stark and anti-kickback updates. And like I said, I hope that we get to do a part 3 next year. Maybe we'll take it on the road.
No more Zoom? Is that the point? No more Zoom?
Okay, Stephanie.
What a great, insightful conversation. Thank you both. We have a couple of questions. We have about 3 minutes left. So my previous organization failed to document fair market value consistently and had a hard time righting the ship. At the organization I'm with now, I'm advocating for proactive measures and putting safeguards in place. How do you recommend gaining stakeholder influence and trust?
Ooh.
Can I do not it?
I'm going to answer it. No, I'm going to start it, and then I think, Ritu, you'll definitely want to add some to what I'm saying.
Okay.
But we've talked a lot about education, right? You can't gain stakeholder involvement and buy-in if they don't understand why they need to be bought in the first place. They also need to understand your policies. You may have a lot of policies in place that maybe your entire organization isn't familiar with. So again, education is not just for your end users or those who are closest to the contracts that are at play here, excuse me, closest to the fair market valuation process, but it's also all the way up to the board. It starts at the very top, and there should be, there's annual education recommendations and requirements, but I can't state it enough that there needs to be practical education of the whys and the risks of not adhering to the policies that you've got in place. Ritu, anything to add?
Yeah, no, I think, Sarah, I think that's a great starting point, right, with education. I think stakeholders want to feel like they can be part of the solution. And so I think once you've done that education, it's really sitting down with the stakeholders and talking about, well, tell me what it is that you're trying to achieve by this, by this arrangement. Why do you feel like, let's just say for fair market value, why do you feel that we need to pay X amount? Obviously, in that education, you've told your stakeholders, we cannot have nefarious intent. We cannot talk about how you want to capture referrals because that is not a valid purpose under the anti-kickback statute. But I think other than that, I think it's really talking about, well, if this is what you're trying to achieve from a business perspective, here are all of the options that we can enter into an arrangement with that particular individual, if it's a physician, for example, and how we can achieve that. And I do think that when you sit down with your stakeholders and you have them be part of the solution and you kind of explain, like if they throw out an idea and you say, no, well, we can't pay that, because if we look at the fair market valuation surveys out there, we're way over the 90th percentile, right? Or, we need to make sure that there are some other extenuating circumstances of if there a reason why we need to be over that point. So I think really partnering with them throughout the process will help them not roll their eyes when you say, well, sorry, this is what we have to pay, and we can't do anything outside of that. And then I think these value-based activities and types of things that we can now track, I think is also super helpful.
Well, thank you so much, Ritu. I think that was really great. Sarah,
Yeah.
anything else to add?
Only that I know that we've had some more questions come in, but we are right at time. But I know that Ritu and I will make sure that you get answers to your questions following this. So thank you again, Ritu.
Okay, no problem. And yeah, we can, Tanika, you tell us if you can give us any of these questions that I see popping up. Sarah and I can draft some responses, and if you can share them with the group, that would be great.
Yes, we got a resounding yes.
Awesome, perfect.
Well, I want to thank everybody for joining today. Sarah, thank you. Ritu, thank you. As always, the discussion was really educational and informative, and we will make sure everybody gets the questions as well as the information shared today.
All right, thank you, everyone.
Thanks, everybody.
This concludes today's program. Thank you, everyone, for joining. The live webinar will be disconnected now.